Good evening, everyone. Welcome to Politics and Prose. I'm Brad Graham, the co-owner of the bookstore, along with my wife, Lissa Muscatine, and we're quite delighted to have with us this evening Michael Waldman, who's here to talk about his new book, The Supermajority, the year the Supreme Court divided America. Now, Michael, who earlier in his career spent some time as a practicing attorney, now heads the Brennan Center for Justice at NYU's Law School. The Brennan Center is a nonpartisan institute that deals with such issues as voting rights, money in politics, criminal justice reform, constitutional law. Reflecting his own expertise and interest in constitutional law, Michael served on the Presidential Commission on the Supreme Court that Joe Biden convened a couple of years ago, and that submitted a report on court reform in late 2021. Additionally, Michael was once a prominent speechwriter who, as White House Director of Speechwriting from 1995 to 1999, put words in the mouth of Bill Clinton. Before that, Michael served a couple of years as a special assistant to the President for Policy Coordination. During those White House years, Michael worked with my wife, Lissa, who was then Hillary Clinton's speechwriter. And this isn't Michael's first appearance at Politics and Prose. He's spoken here for his previous books, among them The Fight to Vote, A History of the Struggle to Win Voting Rights for All Citizens, and The Second Amendment, A History of America's Fraught Relationship with Guns. In his new book, Michael explores the, tumultuous term for the Supreme Court, the 2021-2022 term. And he looks at how the conservative justices reversed decades of social policy over the course of really just a few days last June, issuing controversial rulings on abortion, guns, and environmental protection. It was the most turbulent term in memory, and it included a leak of the draft opinion of the decision that overturned Roe v. Wade, and also included the justices sniping at each other in public. There's more to come this month, for sure, as the court is due to release significant decisions on issues of race and democracy in America. So Michael's book is especially timely. But as Michael makes clear in his book, this isn't the first time the court has veered off into extremism, as some would view it, or ideological or partisan activism. In the first part of his book, Michael looks at several earlier times this has happened over the history of the court, and how it provoked intense controversy and backlash. He contends this cycle of overreach and response is happening again now, and I'm sure it's one of the things we'll be talking about more in a minute. And towards the end of the book, Michael discusses the continued challenges ahead and suggests possible actions that can be taken by Congress and the state legislatures, state courts, and the public to offset the Supreme Court's hard right rulings. So I'm going to take a seat right here next to Michael, and we're going to be in conversation. So please join me in welcoming Michael Waldman. Your seat there. I'll come around here. Going to see just how comfortable or uncomfortable these high chairs are.
Forces me to
sit up straight. That's right. Anyway, welcome. Congratulations, and you and I are going to chat for a bit, and then later on we'll take questions.
I want to say first, as I said to you before, what an incredible thrill it is for me to be back here at Politics and Prose. This is my favorite bookstore in the whole world. It's meant so much to all of us and so much to me. Everything from the many, many hours I've spent here, the books I've bought here, my memories of being here with my then young children, getting the Harry Potter books late at night. And as I mentioned to you, I wrote at least one book in the cafe. And you were concerned that that might imply that I was sitting there all day not spending any money. And I can assure you I ate nonstop.
Yeah.
So.
Well, I was kidding with Michael. When someone tells us, and you know, it happens from time to time. Oh, I wrote my book in the coffee house. Liz and I are never quite sure how to take that until we hear just how much they ordered while they were writing that book.
I was a cash cow.
You were a cash cow. Yeah. And speaking of Lissa, as I mentioned to you, she would have loved to have been here. She's got another commitment. She was a big fan of yours. I guess you guys had a lot of fun back in the old days writing speeches.
Liz is extraordinarily talented. It was great to work with her, and it's, you know, you get to see tons of really interesting stuff if you can work really late and type a lot.
Right. Yeah.
So, at least that was my call to arms.
Yeah. So I guess we better turn to the book, right? So why write this? Why write this book now? What's special about this particular moment?
Well, it was pretty clear going in that this was potentially, at the very least, going to be a very big term in the Supreme Court. This was the first full year, ending in last June, of the new supermajority of 6 very conservative justices, largely moving in lockstep, seeming to be eager to make big changes in the country and in the way the Constitution was interpreted. And as it turned out, things were much more topsy-turvy and much more dramatic than that. This was the most activist court in decades. It was, by most measures, the most conservative court in close to a century. As you mentioned, especially in the last 3 days of decisions in the term, in the Dobbs case, which overturned half a century of protection for women's reproductive rights, in the Bruin case, which was by far the most sweeping Second Amendment ruling in the country's history, and in the West Virginia versus EPA case, which began the effort to curb and pull back on the ability of government to protect the environment and other things. They crammed decades of social policy into 3 days. And what this called to me as a question is, how did this happen? And even more than that, how did the Supreme Court get this much power in our system that 9 unelected people have the power to do this? And how did it happen, and what can we do about a moment like this?
Yeah, well, let's talk a little bit about how it happened. And let's just start with the subtitle of the book, which is "The Year the Supreme Court Divided America." So here's a bit of a chicken and egg question. Is the court responsible for dividing America, or has an already polarized America led to the divided court that we now have?
Well, it's a great question, because, of course, we've had justices on the court before, and they haven't always been quite as predictable in how they're going to rule on things. Right now, this is deeply enmeshed in a very polarized political system. These 6 justices were put in place through intense political action in what turns out to be a very well-funded political machine. But I think it's also the case that the court responded to this not with wisdom, in my view, or restraint, but by doubling down on some very political and politicized rulings. It turns out, when you look at the history of the country, the Supreme Court more or less hugs the middle. It basically mostly reflects the political consensus of the time, or at least of the elite community. And that makes sense, because it has the power it has because we as a country have given the court that power. The part of the Constitution that deals with the courts is only 1/10 as long as the language dealing with the Congress and with the presidency. It's developed this power over time because we have accepted it, because we see it as a court. We see it in some way as above politics. But when the court in the past has been extreme or partisan or unduly activist, there's been a response. It's a cycle of overreach and reaction that turns out to be fairly unusual, but really big in defining the country and how it has developed.
Yeah, I want to come back to that cycle in a minute, but let me cite something back to you that you mentioned early on in your book, and because it's really a curious fact, which is just how was it the court got to be so conservative, given how the popular vote has gone, say in the past 8 presidential elections, because as you note, Democrats won those votes, the popular votes, yet Republican presidents have ended up choosing 6 of the current 9 presidents, and 5 were picked by a president who took office after losing the popular vote. I mean, that just doesn't seem right.
That is one of the things that challenges our democracy and that risks creating a potential crisis of legitimacy. For the court for the Democrats, one party, it's an empirical statement, not a partisan statement, have won 7 of the last 8 popular votes, and that's the longest winning streak in American history for one party. And as you say, not only were 5 appointed by presidents who took office after losing the popular vote, 3 of them were appointed by a president, Donald Trump, who never won the popular vote in either of his elections. And this all predates Mitch McConnell. The last time the Supreme Court had a majority of justices, interestingly, appointed by a Democratic president, was 1970. And here's a trivia question, and Cliff Sloan is not allowed to answer it because I know he knows the answer. When was the last time a Democratic president appointed a Chief Justice of the Supreme Court? 1946. So again, some of that is happenstance. Some of that is politics. It didn't start last week, but it's part of the kind of intrinsic role, the anomaly that this singular institution plays in our society, in that unelected justices serving for a lifetime, other countries do not have a constitutional court set up in that way or with as much power.
Let's get to this issue that you spend a good chunk of the first part of your book talking about, which is this pattern that you've identified over the course of the history of the court, of periods where the court has made particularly controversial, seemingly extreme decisions, and this has provoked a backlash. And you talk about 3 particular times in U.S. history, periods of overreach that led to backlash and offsetting developments. You want to take a few minutes and elaborate on that historical cycle?
Yeah, it's pretty interesting, and I think it should lead to us thinking through a lot of our own attitudes in some ways. The first time was the Dred Scott ruling of 1857, which was only the second time that the Supreme Court declared a law of Congress to have been unconstitutional. As you know, this was at the time of a lot of agitation over slavery, of a lot of rising abolitionism, and conflict. And the justices on the Supreme Court, who were Southerners or appointed by Southern presidents, they said, we're going to, quote, solve this problem. And they issued a ruling that was notorious and continues to be notorious, that said that Congress did not have the power to restrict slavery from the territories. It basically made slavery national. And it also said that black people were so inferior that they could not be citizens and had no rights that white people were going to respect. And this was hugely controversial at the time, and one of the reasons it was controversial, and this was relevant as we think about the past year of controversy, is the opinion leaked. It actually leaked to the incoming president-elect, James Buchanan, who was seen on the, who turned out to have been really involved in lobbying them to go big and bad in this ruling. He was seen on the inaugural platform huddling and whispering with Chief Justice Roger Taney, and everybody said, oh, look at that, we know what that means. And then Buchanan got up and said, well, the Supreme Court is going to make this big ruling on slavery. None of us know what it's going to mean, but let's all just agree that whatever they say, we'll go along with it, right? And the next day, the newspapers all said, oh, well, we know what that is going to mean. The reaction was explosive. Among other things, it led to the rise of the Republican Party. It led to the election of Abraham Lincoln as president. He made attacking the Supreme Court and attacking that decision the basis of his campaigns, and he, even in his inaugural address, actually said, well, there are some people who think the Supreme Court should decide what's constitutional. We all know better than that. They should only be bound by the case in front of them. So this fight over the court and the response to it, and ultimately the Civil War, and ultimately the end of slavery, and ultimately things like the 14th Amendment, was a massive public, popular, political response to the Supreme Court, and something similar happened in the early 20th century. This was a time of industrialization, of immigration, of vast new inequality of wealth in the Gilded Age. And the Supreme Court of that time felt its role was to stop government from doing anything about it, to stop government from protecting women and workers and public safety and those things. This is known to lawyers as the Lochner era, based on a notorious case of the time. What I didn't realize until researching the book was just how intense the political pushback was. Teddy Roosevelt, he did this, he ran for president, as you know, in 1912 in this fabled election where he was challenging his successor, William Howard Taft, and Woodrow Wilson was the other candidate, and Eugene Debs was the fourth candidate. Teddy Roosevelt's big issue was attacking the Supreme Court for Lochner and other cases like that. He had some out there proposals. He wanted there to be ballot initiatives that could overturn constitutional rulings. But this was his big public mobilizing argument. And it actually lasted all the way till the 1930s. We know about Franklin Roosevelt and his fight with the court, who he called living in the horse and buggy days. And the Supreme Court then similarly struck down the first New Deal, and they were getting ready to strike down Social Security and the labor laws. And Roosevelt proposed expanding the court. It was a huge, huge fight, and it was again a massive political debate going on. The third period, and this is a little more complicated for me and for what I do, is the period in the Warren Court in the 60s and 70s. I run the Brennan Center for Justice at NYU School of Law, which is named after the great liberal justice William Brennan, who was such a mainstay of the Warren Court. And I revere so many of the rulings the Warren Court did. But I think it's also the case, looking back at it from more than half a century later, that there were a lot of them, and they were moving pretty fast. And it was the only time when the court was actually ahead of the country in advancing rights and advancing equality. And we now there was a big backlash. It was a basis for organizing. And we're still living in the backlash today to that period. So I think it's important for liberals in thinking about what they want out of a Supreme Court to understand that dynamic.
Yeah, and where you end up after going through these, looking back at these periods, is that you say that we are now maybe in another historical cycle, and there's going to eventually be a backlash to the backlash. Now, is that meant to give us some hope?
I have hope. I hope it's more than just temperament, but I think we're already in that backlash. I think that the public has noticed just how extreme and significant the court's actions were last year. And we have every reason to think there will be more actions in the next month, ripping up long-standing social understandings. And there's plenty of evidence that the backlash has at least begun or maybe well underway. You see it at the ballot box, and a lot of it has to do with the Dobbs case. The 2022 midterm election, as you know, the party of the president usually does really badly in a midterm. It's just part of a kind of political geometry. When President Biden said this election is about democracy and Dobbs, about the response to the Supreme Court, people said, oh, he's ignoring inflation, he's ignoring these things people really care about. The Democrats had the strongest performance in a midterm in decades, despite 8% inflation. And a lot of it was the response to the Supreme Court on the Dobbs case in particular, and some of these democracy issues too. Even more than that, I was really struck by the recent election in Wisconsin for the Wisconsin Supreme Court. As you know, most states have their Supreme Court justices elected. And whether that's a good thing or not, it's a different issue, but they do. Wisconsin is an evenly divided state in terms of the electorate, always very close. Because of gerrymandering, the legislature is not very evenly divided, but the electorate is always evenly divided. They went from an evenly divided electorate to an 11-point win for the more liberal candidate in what was a referendum on the direction of the courts and abortion rights. If that That's political scientists will tell you that kind of thing doesn't happen. That's an earthquake. And so maybe it will be a short-term thing, or maybe it will be part of a longer-term response if people understand in part how all these different cases and institutional aggression and power grab all hold together.
So for those of us who've been upset with this court and its recent rulings, there's maybe some light at the end of the tunnel, but it's also likely that this tunnel's still going to get kind of dark, right? Because I mean, just any day now, right? The court's going to hand down some of its most important decisions from the current term on affirmative action, on the Voting Rights Act, on election rules. What do you? How much more damage do you think that all these decisions are going to cause?
You know, I think they're going to be very significant. The as you say, is we're talking at the beginning of the month of June when they have all these rulings kind of tumble out. Very soon we may hear, for example, a ruling on the Voting Rights Act. This Supreme Court, and going back over a decade, has been absolutely brutal to voting rights in this country. One of the things the book talks about is that John Roberts, the Chief Justice, really does seem to be an institutionalist, does try to move the court to the right, but steer it somewhat carefully with an eye toward public credibility and public approval, but not on the issue of democracy. On the issue of democracy, when you think about Citizens United in 2010 or Shelby County in 2013 or a string of rulings on voting rights, he and the others have been very aggressive. And there's a case that may make it very hard to use Section 2 of the Voting Rights Act, the remaining shard of a useful law, against gerrymandering, racial gerrymandering. In other words, drawing district lines in a way that dilutes the effective voice for black communities and communities of color. Then, of course, there's the affirmative action cases, which seem likely to result in the court declaring that you cannot use race in any kind of way of assessing admissions to higher education. And there's obviously a lot of controversy around that, but there's no question it is going to be ripping up the way thousands of students are admitted to schools and really upending higher education in this country. And then there's a case which is, the case is called Moore versus Harper. It deals with something called the independent state legislature theory. Calling it a theory is very generous. This is the idea that the Constitution gives state legislatures the power to set election rules for federal elections with no checks and balances from state courts or state constitutions or governors or voters in the states, and that nobody ever noticed it until now. It's a cockamamie theory. It's a fringe idea. It's never been upheld by the court. It's not how any state runs it. But at least 4 of the justices thought it was a good enough idea to take the case. Now, I think there's both such a strong argument that was made against this that it went much better than one might have feared, at least in the public debate over it. But also, they may declare it moot. They may say they're not going to rule on it because the state Supreme Court in North Carolina, which had blocked a gerrymander, a partisan gerrymander, they had an election, they have some new justices, and now they've blessed the gerrymander in question. So we're looking especially for the affirmative action cases and the voting rights cases, and it's an interesting thing if you think about it. If you look at the big cases at the beginning of the supermajority's control of the court, the ones from last June, it was guns, it was abortion, and it was the interests of the fossil fuel industry. That sounds like a caucus meeting at the RNC. These issues are visceral issues of race and democracy. There's nothing that's changed in the law. The facts have not changed. All that has changed is the personnel on the court. And that's one of the things that causes people to lose faith and lose confidence in this as a court as opposed to a political body.
Yeah, of course, if you ask the conservative justices making these decisions, they don't see themselves as being outside of the mainstream or, extremists. They talk about correcting what they consider were in some cases bad decisions. They talk a lot about being guided by originalism, and you talk about that too some in the book, meaning that they see their role as determining what the founders intended, and then applying that to the present day. I mean, how does that approach compare to the way the court has historically operated?
I think folks don't necessarily realize just how dramatic a change this is and how new this is. Really, there only been 4 major originalist rulings in the country's history. The first one was Dred Scott. The second one was in 2008, the Heller case, which was the first time the Supreme Court said that the Second Amendment protected an individual right to gun ownership for self-defense. And then 2 last June, Dobbs and Bruin. And it's a really radical approach if followed through. What it says is that the only legitimate way to understand the Constitution is what it meant to the people who ratified it at the time. What that means is that we must be governed by the social views of, by and large, property-owning white men from the late 1700s. That's actually what it means. And there are all kinds of problems with it. First of all, saying you're just following history assumes you can know exactly what the history is. The founders disagreed with each other. They changed their minds. One of my favorite things is that lawyers and high school students all know the Federalist Papers. And Federalist number 10 is this famous essay that James Madison wrote. Now, these were just op-eds written in response to other op-eds anonymously. In Federalist 10, Madison said, the thing that's worst of all, this whole system is designed to avoid, quote, faction, to avoid political parties. We quote that all the time. We say, originalism tells us that's what we've got to follow. Then 2 years later, he founded a political party, the one we call the Democrats. So he started writing other op-eds anonymously under another name saying, some people say factions are bad. That just shows they don't know anything about history, because obviously there's always been 2 political parties. In other words, the idea that we would somehow be trying to read the tea leaves, go back in a time machine, tap them on the shoulder, and find out what we ought to do, even if that was the right approach, it's actually very hard to do. The notion of history that is, as I say in the book, that is used often has the subtlety of the medieval times costumes, at a theme restaurant. But even when it's not wrong history, it's just explicitly reactionary in its implications. In the Dobbs case, as you may remember, one of the things that shocked people so much when it leaked, it cites 6 times a guy named Matthew Hale. He was an English jurist. They hadn't become Great Britain yet. From, I think, the 1500s, who sentenced women to death for witchcraft, and who developed the doctrine that a husband cannot be guilty of raping his wife because she consented to it by getting married. They cite him 6 times as the expert on what the rights of women ought to be. And it sounds like a caricature. Saturday Night Live actually did a great rendition of it, but the backward social implications cannot be denied. The idea that in 2023, this modern, growing, diverse, changing country, which has evolved over 2 centuries, suddenly now we're going to go back and do it the way they did in the late 1700s or the 1800s, is an absurd way to run a modern country, and it's never been tried before. There is, ironically enough, no history and tradition of governing ourselves only by history and tradition. It's as of last year.
Yeah. Well, another thing that seems somewhat contradictory to going back and trying to rely on you pick your time, whether it's the 17th, 18th century, or as you were saying, the 15th or 16th century. Is that, precedent used to be important. What in the legal jargon is called stare decisis. That now, at the same time that we're hearing a lot about originalism, we're also hearing that, well, maybe precedent doesn't always matter. How is that happening?
It's Clarence Thomas, who in so many ways is the dominant force in the court. John Roberts holds the gavel, but Clarence Thomas holds the influence, and in many ways holds the power. Thomas said, stare decisis, that's for when you don't want to think. That's basically a lazy cheat for not thinking. He has had his own jurisprudence over many years, which was at the fringe of the court, which was that he didn't care about precedent. He was going to look and see what he thought the right interpretation was based on his reading of the past. But it's very hard to see how a court functions as a court without precedent. And this is something, interestingly, that John Roberts and Elena Kagan and others have talked about with great passion, that courts, if a court doesn't have to decide, it has to not decide. Even when Thurgood Marshall and the others in the NAACP Legal Defense Fund were making the arguments for Brown versus Board of Education, which is such an important case, they pieced that together with precedent. That's the only way one can possibly understand this as a legal matter. And again, it just makes clear the extent to which this is seen by the public as an abrupt lurch to the right and based not on the law, but on personnel. And going back to the question of, public response, part of what's going on is the country is moving in one direction and the court is veering sharply in another direction. And that creates the potential for a real crisis of legitimacy.
It's not only, of course, the court's decisions that have stirred up so much controversy recently, it's the behavior of some of the justices. And that brings us to the whole issue of ethics and whether the court should accept and begin enforcing more rigorously a binding code of ethics. Why is that? Why is it so difficult for the court?
My view, our view at the Brennan Center is nobody is so wise that they should be the judge in their own case. And so the Supreme Court should have a binding code of ethics just the same as every other court in the country. Right now, they don't. And as you know, the recent revelations about Clarence Thomas show why it's so important. This is not, I wrestle with the word ethics because to me it's about corruption. To me, ethics is, should I have taken that cup of coffee or not? We now know that Justice Thomas had his lifestyle subsidized for decades by this activist right-wing billionaire. It was disclosed for a while, and then the Los Angeles Times wrote about it, so he just stopped disclosing it. And it led to, it wasn't just luxury jet trips and things like that, but the guy bought Justice Thomas's mother's home and renovated it, and she's still living there. And he paid for the education of Justice Thomas's surrogate child. I mean, this is very basic, classic stuff that you read about in the past relating to members of Congress and others. I think there is absolutely a legitimate role for Congress in investigating this, and I just heard today that Harlan Crow, the individual who was the benefactor, is talking to the Senate's Judiciary Committee.
Well, I think his lawyer has offered to come and talk to the staff, but it hasn't gone so far as him expressing a willingness to.
They should ask to do it in a really nice location somewhere, because
on a yacht.
Yeah. On a yacht, yeah. But look, I think that there's something more fundamental even than just this rather garish story. To me, one of the things that was so striking in the really important ProPublica, exposés that broke this was this painting. And it's a painting of Justice Thomas and Harlan Crow at this luxury resort. And the painting, honestly, to me, looks like the dogs playing poker, kind of painting. They're all sitting around, but they're smoking cigars. But with them is a third person, Leonard Leo. And I don't think that Justice Thomas became conservative because this guy bought him, a plane trip. I think that what we're seeing is a glimpse of a world of privilege, but also the workings of a political machine. Leonard Leo, as many of you certainly know, is the leader of the Federalist Society, which started as a student club, has grown to be enormously influential, provided the names to President Trump when he was a candidate of who he would put on the Supreme Court, and is very, very significant in pushing conservatives onto the bench and encouraging them to stay conservative when they're there. And I will tell you that we used to look at the Federalist Society and say, they're really very effective and interesting because they don't seem to have that much money. Well, it turns out somebody had given Leonard Leo a couple of years ago $1.6 billion to run this political operation. They run ads for the justices' nominations. They run ads about the court. They fund groups. Leonard Leo's operation funds groups that then file briefs with the justices and the judges who've been put on the court. And it's not just the Supreme Court. It's all throughout the system. And so what we're seeing is a faction of a faction has captured this branch of government, and it's a branch of government with lifetime appointments, and that's not elected, with much less recourse than would be the case if it were an elected branch of government. And I'm not aware of any time in our country's history where we've had that kind of political takeover of the courts.
And another thing that really emerged the year that you write about in your book is this much more open kind of sniping and criticism of each other that you see among the justices. It's not just that the conservatives and Republicans, conservatives and liberals disagree, but they're openly taking pot shots. How concerned should we be about that?
As I was saying to you before, when I was actually approached by the publisher to write this book, a year or so before the term ended, one thing was I knew that I wasn't going to have, and I wasn't going to try to have a lot of inside dope. I didn't need to. An earlier observer of the court once said that the Supreme Court are like 9 scorpions in a bottle. And now the scorpions are crawling out all over the table. Justice Thomas, for example, actually gave a speech where he said, this was a great place to work until John Roberts became Chief Justice. He didn't say Roberts' name, but that's what he was saying. They've criticized each other for overreach. They've criticized each other for being critical. This has happened before, but what the problem for them, I don't know that it's a problem for the country. I think it's a problem for those justices who are trying to make a very big political move here. They're trying to make a big political move, but cloak it in the aura of mystery and sobriety and wisdom that we attribute to a court. I always say they wear robes. They're not wizards, but they wear robes. They're not in a religious order, but they want to have this sense of deliberation and silence, even, as a way to improve our willingness to accept their rulings. And that's always been, we want a strong court system, we want an independent court, and that's part of it. We don't want them out there, tweeting nonstop or whatever. So when they're this fractious in public, and as you remember, Justice Alito, for example, took a victory lap after Dobbs and made fun of his opponents, made fun of his critics in Rome at a speech to an academic conference. Over and over again, that makes it harder for them. Public confidence in the court has collapsed by all the polls to the lowest level recorded ever. Again, that is a challenge for them as they try to continue to push what they're doing, but it's also a challenge for the country in terms of the legitimacy of the system.
Of course, the most astonishing event to rock the court during the term you write about was the leak of the draft of the majority opinion in Dobbs, and you devote a whole chapter to that, appropriately titled "The Leak." This was, of course, a very rare breach in the wall of secrecy that typically surrounds the drafting of court rulings. So what's your view of who did it?
It's the ultimate true crime podcast. I don't really know. I'll tell you, my first reaction when I heard it was sort of Occam's razor. I kind of assumed it was one of the liberal clerks or a liberal staff member who was outraged by the ruling and wanted the world to know. But the more I looked at it, and again, I don't know, but the more I looked at it, there is a pattern and practice of leaks on the conservative side to this very loquacious, I guess, and very wide, far-flung network of clerks and former clerks and activists over the past decade and a half or so. And those leaks have all come from the conservative side, and they've been around trying to stop defections from the conservative position. So you might remember that the Affordable Care Act case, John Roberts originally voted to strike down all of Obamacare with the others, and then had second thoughts. And so, as one person wrote, as a contemporary matter, they said the bat signal went out, the word got out, and there started to be all these public articles and everything saying, "Don't go wobbly, John Roberts." There was something similar that happened in a more recent case called Bostock, which was a major LGBTQ rights case, where suddenly, a month before the ruling, you start to see articles saying, uh-oh, Neil Gorsuch, don't fall for Elena Kagan's arguments. And you saw people saying, wait a minute, looks like there's been a leak there. And then a week before the Politico article, the Wall Street Journal editorial page had basically the same thing. They didn't have the actual document. But then, to me, the ultimate tell was a week after the ruling, Politico had another article saying, well, the 5 votes have still held. Well, they didn't hear that from Sonia Sotomayor. That seemed to come from the conservative side. So, I want to be careful not to just let my own priors, I'm not a forensic investigator here. I will note, however, they did not actually do much of a real investigation to find out who leaked it. They used I believe the clerk of the court that's, somebody with an estimable career in government, but who says oye, oye, oye when they come out. And apparently they did not ask the justices themselves whether they had leaked it or not. So I don't know that we'll ever know.
We'll see. I've got one more question for you, Michael, before we'll turn it over to the audience. So if you'd like to ask a question, now would be a good time to start lining up right here at the microphone at the base of the pillar. All right, so we've spent much of the time so far criticizing the court. I did mention in my introduction that you were on the commission, President Biden's commission, to look at reforms for the court. So my last question is, so what's to be done? What can be done by the public and others going forward to try to bring about some change?
I think there are a lot of things that can be done. This is a lot of what we at the Brennan Center, the organization I lead, what we work on right now. First of all, there can be and should be reform of the Supreme Court as a central issue. I mentioned a binding code of ethics. The other thing that I think is really significant that should happen is term limits for Supreme Court justices, an 18-year term. I would couple that with a regular appointment so that presidents get to make an appointment or nomination every 2 years, which hopefully would drain some of the corrosive toxicity out of the nominations process. This is rooted in the notion that nobody should have that much power, for public power, for too long. George Washington had that insight when he stepped down from the presidency after 2 terms. What's interesting is it's really popular across the political spectrum in ways I'm always surprised by among progressives and conservatives. So as you mentioned, I was on the Supreme Court commission that President Biden appointed. And, these commissions often are kind of don't do anything or are designed to deflect action. And we were actually ordered not to reach conclusions at the beginning in public. This was the executive order. And we didn't. It was finally a government agency that worked as intended. But something really interesting did happen. We heard from dozens of public witnesses from left and right. Some were for court expansion, some were against it. Some were for a code of ethics, some were against it. Over and over again, they said, oh, but I'm for term limits, of course. There's a wide consensus for this. Now, would that last if it actually started happening? I can't guarantee that. How could it happen? It certainly can be done by constitutional amendment. We think it could be done, too, by statute. But I think this is an idea whose time has come, and I think there's going to be a lot of pressure for it. There are other responses, too. Congress can act to push back at the Supreme Court. The Voting Rights Act can be restored to full strength by Congress. That was what the John Lewis Voting Rights Advancement Act would do, which was filibustered, even though it had a majority of the Senate and passed the House. If Congress is willing to change its rules and actually act, they can fix a lot of the damage. There's also things we can do other than that. We should not be afraid, we think, of constitutional amendments. There's been a great allergy to talking about that, and they always seem really impossible to do, as they do right now. But then about every 50 years or so, things get bad enough, and there's a burst of them. And I think we're both overdue in chronology, but also overdue in terms of the things that need to be addressed. We also should look at state courts and state constitutions as a way to have countervailing force. State courts can be a bulwark for protection of rights and promotion of equality. A lot of people don't realize, for example, that all but one state constitution has a stronger protection for voting rights than the U.S. Constitution does. They just need to step up and, instead of saying on this or on other things, oh, we're going to kind of follow what the federal courts say, realize they have enormous power. And this is not just on voting, it's on reproductive rights, environmental protection, all these other issues. That's actually something that the Brennan Center has pushed into, and we have a website, full website launching called statecourtreport.org, which is launching next month, which is going to be a way for people in all these states to talk to each other and learn about what's going on. There's a great deal of ferment there, not just us, others too. So I think there's a lot of things that can be done. Most important of all is people need to vote about it. This is something where one of the things I say at the conclusion of the book is really addressed to my fellow liberals. You know, conservatives have understood for decades how important this is. They organized the campaigns that led to Dobbs and Bruen were campaigns decades in the making. And liberals, in a lot of ways, were bedazzled by the memory of the Warren Court or lost the muscle memory of how to organize on these issues. And I think that if liberals wake up and realize this is a voting issue and we need to be asking politicians what their views are, and you need to hear Democrats talking about who they'll appoint to the court just as much as Republicans, that's another way to push back too. And that's a power that's in all of our hands.
Okay, questions?
Okay, thank you very much. And you're my one mic here. Your list that you just gave of things that could be done is a great introduction to my question on court packing. Can you give us a quick summary of your views on it? Would it be a bad idea because it would lead to tit for tat changes in the composition of the court, size of the court?
Yeah, I mean, you're raising good points. So Congress has the power to expand the size of the Supreme Court. Many people just assume it's 9 in the Constitution. It's not. Congress has expanded the size of the court, and it's shrunk the size of the court before. And it's, of course, an idea that has a lot of support from a lot of people who are really justifiably angry about, in my view, justifiably angry about this court and what it's doing. I always throw out some notes of caution. First of all, you identified one of the issues. It would very likely lead quickly to a retaliatory spiral. Democrats add 5 justices, then Republicans add 5 justices. Pretty soon you would not be able to fit people in the courtroom. That's one very fundamental challenge. There's another one, which is it's very important. There's always a risk with any of these reforms that we not do anything that appears, at least, to put at risk judicial independence. And I think that there is potentially a silent view among many people, even people who don't like this court, who might be turned off by something they also thought was a problem. FDR, we saw something like this, I would say, in the streets of Tel Aviv in recent months, where people protested because they thought that their courts were under attack.
Huge numbers of people.
Huge numbers of people, but I would say FDR offers us a cautionary note. I mentioned the extraordinarily active and reactionary court he was dealing with. They were known as the 9 old men back in the day. And FDR had just won the biggest landslide election in American history and had 70% of the Senate were Democrats. And they'd struck down the first New Deal, and they were about to go after Social Security and labor laws and other things that were really popular. And when Roosevelt put this forward, he found a surprising, massive rebuke from his own party and from the public. I think people need to really carefully look at public attitudes on something like this. It doesn't mean it's always the case. Now, some people note, so Roosevelt lost, but the court backed down. It's known as the switch in time that saved 9. They actually suddenly started upholding these regulatory laws. So it helped. The 1937 fight over the court helped create this new constitutional order, but also demolished the New Deal coalition at its peak. So, look, it's absolutely legal. There are times when it's the right thing to do. I say to people, come see me after the independent state legislature theory case, because if they go really all the way on that one, I might be on the barricades. You never know. But I think it's important that as we look at this, we know that term limits would greatly improve the court, and we know it's widely popular and seen as very legitimate. And that's at the Brennan Center. That's what we're pushing for. I know other people are pushing for court expansion, and I'm glad that they're out there making their case.
Okay, so I'm a big fan, and I support the Brennan Center, and I'm an attorney. I was in Hillary's class at Yale Law School. My late husband was in the Clinton administration. He was at Yale Law School too at the same time. I practiced with the federal government. I became so discouraged with law that I quit and became a physician. That's how bad I thought it was.
I'll confess I wasn't expecting that plot twist.
Do you talk in the book about the fact that the Republicans play by a different set of rules, and when the rules don't work for them, they change the rules, and we play by the same rules. We nominate moderate judges. They nominate, and they have since Bork, the most reactionary judges they can get on. And when those reactionary judges can't get through and can't get a majority, they change the rules so that all they need is a simple majority. They don't care if they don't get 70 or 60. They're content with 51, and they'll squeeze it out if they have to. If we play by the rules and they play by not the rules, like when you can fill a seat, like Mitch McConnell did, we can't win. They have tipped the board so much with the gerrymandering, and of course the Constitution original gerrymandering. I don't see how we can, we'll have term limits and this and that. And that's 18 years in the future. I'll be dead by then.
Well, there's ways to do it that would give presidents the appointment ability to add people in the meantime. You're not wrong in the following sense. This goes to the kind of growing gap, I would say, between the court and the country. There's a lot of aspects to the American political system that were tolerable at one time or another. Mm-hmm. We have the oldest written constitution in the world that doesn't, and we revere it, but when they wrote other constitutions later, they fixed some of the mistakes that we made in our constitution. There were things that were tolerable or were seen as kind of quaint Americana, but over time as the country has changed, they've grown more and more problematic. The Electoral College. When I was growing up in politics, the Electoral College was for aficionados. For well over a century, it had always followed the popular vote. Now, as you know, and the popular vote was what was seen as the legitimate way presidents got elected. Now, twice, of course, in the last 20 years, the person who lost the popular vote became president. And interestingly, it almost happened again in 2004. Doesn't just help Republicans. John Kerry lost the popular vote handily to George W. Bush, but if a few thousand votes in Ohio had changed, he would have been president. So the Electoral College is something that was once tolerable and is now out of whack. The Senate, just the very institution of the Senate, by giving each state 2 senators, which was not popular with most of the framers at the time. They saw what the problem was, but at that point, Virginia was 7 times the biggest state, was 7 times larger than the smallest state. Now California is something like 47 times larger than Wyoming. There's a massive imbalance there. The gerrymandering, which is not new, is vastly more sophisticated and effective than it has been.
Yes, computers.
Computers. It used to be that each state had somebody like the master gerrymanderer in California would draw the maps on a tablecloth in a restaurant in Sacramento. Now they're all done by computers, and the Supreme Court in 2019 said that it would not police, and in fact, no federal courts were allowed to police partisan gerrymandering. That's in the Rucho case. So gerrymandering is a worse problem than it was in that way, and of course the Supreme Court lifetime tenure it used to be that people weren't on the court as long. They didn't, I hate to say it, they didn't live as long. Now, justices are appointed at a much younger age for much more explicitly ideological purposes, and they stay on a lot longer. So again, lifetime tenure was tolerable, perhaps at one point, but is less and less so. And it's also interesting and worth noting in terms of thinking about, because remember that the change to 50 to a simple majority for judges was done by the Democrats to get lower court judges on.
Because they were
first.
all being filibustered.
But I will note that part of the result of that is that for the first time, President Biden has not only been able to appoint a lot of judges, but has appointed civil rights lawyers and public defenders, and not just prosecutors and not just corporate lawyers, to these judges. And I will, one of them, the longtime director of the Voting Rights Program at the Brennan Center, is now a judge on the Second Circuit, to give one example. So I think that I don't think it's all one side. I think the polarization and politicization of the process leading up to these judges is not all, honestly, all one-sided. But one other thing that's kind of interesting, we're used to thinking that right now 8 of the 9 justices were appeals court judges before they were on the court. That is, too, a big change from the history of the country. It used to be that the people on courts were governors, senators, attorneys general, a former president of the United States. And now it's technically proficient, skilled, but narrow ideologues who were appellate judges making rulings where they very proudly say, we're not going to consider the implications of our ruling on the public. At least that's what the majority says. That may be a little braggadocio, where they're kind of, the louder they say it, the more you know they're worried that they're losing the audience. But that, too, is a big change.
You haven't mentioned dark money. I hope you mention it in the book.
Absolutely.
Hi, thank you so much for sharing your insights with us tonight. Talking about reform, it seems like your main point of optimism is this idea of backlash, and that reform could come out of backlash, but that'll ultimately be like a fundamentally political solution. So do you foresee a scenario in which kind of a bipartisan consensus for reform could form around something like maybe less extreme than court packing, but maybe something like term limits, maybe because, let's say the conservative legal movement and the Republican Party get out of lockstep. How would you see that happening? Yeah.
So I think the politics on something like term limits are going to be complex, even though, again, there is currently a wide public understanding of it and support for it. But you're right. I don't see the answer here as coming from lawsuits or briefs or judges. I think the court where this is going to get all fought out is the court of public opinion. And one of the consequences of that, both broadly speaking and on specific issues, and I talk about it in the book, is the power of the Supreme Court and the courts developed over the years, forcing so many issues into being thought of as first and foremost litigation. That makes things about rights and individual rights, and it forces almost a binary approach to things. Either you have the right or you don't, or is the right being impinged on or not. When things are in the political arena, compromise, by and large, is necessary. It has to happen that there's compromise most of the time to get things through Congress or through a state legislature or the political process. And so that, too, is going to force changes in the thinking of liberals as well as conservatives, because we need to understand that moving things through the legislature there is not the same as declaring a right, getting a judge to declare a right. Now, it's been many, many years since progressives have actually won these victories in the courts. But the glow from the time when they were winning those victories lingered a long time after the facts justified it. Until quite recently, public opinion polls showed that Democrats had a much higher opinion of the U.S. Supreme Court than Republicans did. I mean, like 2 years ago. I don't mean 25 years ago. Progressives need to use Abraham Lincoln's phrase, we need to disenthrall ourselves from thinking that the Supreme Court is going to save what we care about or should be the place that saves it. For most of the country's history, the rallying cry for progressives was judicial restraint, understanding that above all else, it's best You want rights to be protected, but it's really good if you can get the political process to validate those rights, because they're deep in people's hearts when you do. So I think there's a lot of rethinking that has to happen among progressives, among the liberals, at a moment like this, looking at the reality, staring in the face at what's happening at the Supreme Court, because it's not really so new, but it's now it's unavoidable.
Right. Thank you.
Okay, we have time for one more question.
Oh, so much pressure. Yeah, I was wondering, based on sort of the current disregard for precedent, it seems to me that, like, as you open talking about sort of periods where the court is in conflict with the country, maybe, that now the court is even more, like, in conflict with its past self by just sort of, like, blatantly disregarding all these past precedents. And I wonder what you see in the future as, like, if maybe a more reasonable court comes along, if there's a way to sort of, like, return to an emphasis on precedent, and how you do that when you have all these cases on the books that are just sort of like random ideas, or if there's a way to sort of, like, play by the game.
Well, so, I mean, there have been other... The courts at times overrule precedents, but there's kind of a set of principles by which they decide when that's okay to do. New facts or unexpected consequences of earlier rulings or things like that. Now they're just saying, as was said in the Dobbs case, oh, well, this case, Roe v. Wade was just egregiously wrong, so we're overturning it. And they always point back to Brown versus Board of Education, like, as a talisman, like, see, we did that then, and that was good. So therefore now, anything we do now, we can say is like Brown versus Board of Education, right? I think a whole new way of understanding the role of the courts can lead to a more cautious jurisprudence, even when the judges are more akin to what I might want. I don't think this is really very high on people's minds, but I hope that people don't just think that if some miracle were to happen and you could have 9 progressive Alitos making rulings like Alito would, but just with a different point of view, that would be a good thing. I think that, one example recently, which was interesting and important and is a challenge to the idea of judicial restraint, is on marriage equality. The Obergefell case was the case where the Supreme Court upheld the necessity for marriage equality under the Constitution. And at first blush, you could say, well, this is like one of those big rulings like in the past that was just such a big change. But actually, both the activists who pushed for it and the judges involved were pretty cautious in thinking through how to build as much public support and consensus for it before the ruling happened. By the time of the Obergefell case, and the court had punted a couple of times to get it down the road further, so many states had legalized same-sex marriage through the legislative process, which once seemed impossible to imagine. Public support was at about 57% for it at the time of the ruling, and now it's gone up. So in a way, in that example, the country ratified same-sex marriage before the court ever did. I think you want the courts to stand up against the crowd. You want the courts to protect rights. You want the courts to be what's called a counter-majoritarian institution. Sometimes you have to sail against the wind. But more broadly, we want the courts to be part of building a modern country, a diverse country, and a future-oriented country, whereas right now, using the claims of originalism, these justices are working really hard and very explicitly to turn us back toward the past. And I don't see that as a sustainable thing in the end.
Well, thank you, Michael, for a very lively and instructive discussion. Copies of the Supermajority are available at the checkout desk. Michael will be up here signing books. Please form a line to the right of the table and help our staff by folding up your chair.